what are the policy considerations and reasons why we have the Mandatory Fee Arbitration Act? And they're really, it's an efficient way to resolve disputes. I've been involved in lawsuits over legal fees, and like any other lawsuit, they can take a number of years to process and culminate with a multi-day trial. Fee arbitration, on the other hand, from the lawyer's perspective, if the client elects to go to fee arbitration, you can be in and out in 3 to 4 months in a half-hour hearing and have a ruling that may or may not become binding, but if nothing else, provides some insight on where you are. And I've had a number of fee arbitrations that, although the parties didn't agree to the award, the resulting award was a basis for negotiating a settlement. Fee arbitration is voluntary for clients. That means if clients can opt in or opt out, but if the client opt in, it becomes mandatory for the lawyer. And one of the reasons for that is that it provides the client the opportunity to go through a more informal process that's not as threatening as going to court, and gives them the opportunity to be heard. One of the most important things when a client opts into fee arbitration, many lawyers may say, oh my gosh, the client is opted in for fee arbitration. That's a bad thing. I wish I could just sue them. No, they've opted into fee arbitration, which means they've embraced that expedited process. It also means they're less likely to sue you for malpractice than if they had to go get another lawyer to look at their case to think about whether or not there's some issues. We'll talk about in a bit that when you have a 3-arbitrator panel, there's a lay arbitrator. One of the things that does is provide the client the feeling, and hopefully more than just the feeling, but actually the view and the impression that they got somebody who's not a lawyer to hear the dispute and to weigh in, and that can also provide some additional benefits to the client.
We were actually talking about that the other day, though, and saying that at times that might be a little almost illusory in at least some of our experience, not 100% of the time, but plenty of times. The parties that are the most critical of the attorney's work and the attorney's billing are the other lawyers. At least in our experience, just about every attorney we've ever met can look at somebody else's file and say, I could have done this better and cheaper. And so if you think about, the potential that your arbitration panel is made up of 2 of those people as opposed to 1 lay person, it might be that some of your panels are actually stacked against the lawyer because their perspective works against the bills as opposed to in favor of it.
The other side of that coin is sitting as an arbitrator and representing clients, I've probably been involved in 20 to 25 matters that have gone to hearing. And there's a definite circuit of retirees who like to be lay arbitrators. And I've had the same one show up on multiple occasions. So there's folks out there that are doing this to keep themselves interested and occupied. Sitting on the State Bar Committee on Mandatory Fee Arbitration, I've heard the statistic, I don't recall exactly what it is, but roughly 80% or more of the matters that go through fee arbitration do not result in a follow-on lawsuit. So fee arbitration keeps things out of court. And then the thing about fee arbitration that lawyers may not like to hear is that when a matter goes through fee arbitration, if the lawyer is required to give a refund, there are provisions in the statute, which we'll look at in a few moments, that are designed to make sure the lawyer makes good on their obligation to the client. So there's some really important things in there. We'll talk about what can and cannot go to fee arbitration. So really, it's more about what doesn't go to fee arbitration. Fees that are to be set by a statute are not the scope of within the scope of fee arbitration.
They are not.
They are not. So whenever, for example, in an employment matter where the court is to set the fees that the prevailing party is to receive from the other party, that's not a matter for fee arbitration. Any fees to be set by court order are not for fee arbitration. Disputes amongst lawyers, and we've had a couple of those recently where, for example, there's a fight about a referral fee on a contingent fee or a co-counsel arrangement or any referral fee arrangement. Those are not subject to fee arbitration. If a client files a lawsuit or an arbitration proceeding seeking affirmative relief, they've forever waived their right to go to fee arbitration. So if the client sues the lawyer for malpractice, they can't then separately bring a fee arbitration matter with respect to the fees. They've waived it, it's off the table. Additionally, the client only has 30 days from the receipt of the notice of client's right to fee arbitration to seek fee arbitration. After that, it's passed. Now, the lawyer and client can stipulate to put it back into fee arbitration, and there are many instances when that might be a good idea, but once that 30 days is expired, the client loses the ability to compel the lawyer to go to fee arbitration. So I want to talk about some of the important statutes. So to start with, in the materials we circulated, we gave the entire statutory scheme, which is Business and Professions Code 6200 through Business and Professions Code 6206. That's all it is 8 statutes. One of them has a subdivision, but they're pretty long statutes. So I've just done the vast majority of these in sequential order. So first and foremost, if you sue the client for unpaid legal fees and they elect into fee arbitration, that means your lawsuit is stayed pending the resolution of the fee arbitration. And there's a form that is in the judicial council forms the lawyer's supposed to file at that point to let the court know they've elected into fee arbitration. That's an automatic stay pending the resolution of the fee arbitration.
If you send out a notice of client's right to arbitrate and the client elects to do the arbitration, does that toll any statute limitations?
It does, and we're going to get to that. And there's been a recent amendment to the statute of limitations for claims against lawyers to broaden it that was signed by the governor late June. And there's some interesting nuances there. So as we mentioned a moment ago, under the 6201D, client files a lawsuit, they don't get to elect into fee arbitration. That it's off the table unless the parties stipulate. And there may be some compelling reasons to do that depending on the nature of the issues that the client's presented against you. So that's something you would want to analyze on a case-by-case basis. One of the things that comes up in my practice quite a bit is that there's an open question about whether a third-party interloper can take advantage of the waiver of the attorney-client privilege that occurs when a lawyer and a client sue one another. Last I looked, there's not real good case law. But what's interesting is within the fee arbitration statute, Business and Professions Code 6202 contains the last highlighted paragraph, which is, or sentence, which is important, which is, in no event shall such disclosure be deemed a waiver of the confidential character of such matters for any other purpose. So when we're asked to look at a potential fee dispute for a client and their underlying matter is still ongoing, but they've got statute pressure, we oftentimes give serious consideration to bringing it first to fee arbitration so that we can take advantage of this in the event that another lawyer involved in the matter, another party involved in the matter, serves a subpoena on our client trying to get the privileged communications between them and the lawyer that they've now got a problem with. Because at least this gives us another statute to point to that doesn't otherwise exist. So this is something that when thinking about fee arbitration, if you're representing clients in fee disputes like I do, this is something important to consider. Another interesting wrinkle about fee arbitration, the fee arbitrators cannot award affirmative relief for malpractice. So a client brings a claim in fee arbitration, the arbitrators cannot give them a recovery because the lawyer made a mistake. The arbitrators can consider evidence of supposed malpractice or ethical breaches in determining the value of the fees, but they can't award any affirmative relief. And so, like I mentioned a moment ago, if a client brings a claim in fee arbitration, that does give you a little bit of cover from a malpractice claim. And before about a month ago, that would also mean that the statute on the malpractice claim would continue to run, and you might get lucky and run out the statute.